No state shall deny to any person within its jurisdiction the equal protection of the laws. The command to treat everyone equally is written as a categorical rule without any apparent room for exception. But we can readily think of dozens of examples of how governments treat people unequally. Here are just a few. 18-year-olds can vote. 17-year-olds cannot vote. Men have been subjected to the military draft. Women have not been drafted. Medical doctors are allowed to write pharmaceutical prescriptions. Chiropractors are not allowed to do so. Girls are being allowed to wrestle on boys' high school wrestling teams. Boys are not being allowed to play on girls' field hockey teams. College students from North Carolina pay a significantly higher tuition at the University of Virginia than do students from Virginia. It should be obvious that the principle of equal protection is not being interpreted to demand absolute equality in every situation. In 1918, the Supreme Court made one of the earliest important interpretations of the Equal Protection Clause. The case was called Northwestern Mutual Life Insurance Company versus Wisconsin. Northwestern complained that because it was a corporation based in Wisconsin, it was taxed at a higher rate for the same activity as life insurance companies headquartered in other states, but who were conducting business in Wisconsin. The Supreme Court ruled against Northwestern, saying, "The state is not, because of the 14th Amendment, required to tax all property alike. The classification may not be arbitrary and must rest upon real differences. Subject to these qualifications, the state has wide discretion." Thus, the Supreme Court created a new legal rule that said that the 14th Amendment's Equal Protection Clause only prohibits arbitrary forms of discrimination. If there are two groups and there's real differences between the groups, then it's okay, it's constitutionally acceptable for the law to reflect those real differences. I hope it's obvious that there's a lot of room for personal opinion and subjective decision-making when your standard is, are there real differences between groups? Is there a real difference between men and women? Or are such differences arbitrary? Are age differences valid? Is there any time that it's appropriate to conclude that there are real differences between the races? Does it make a difference if it's the minority group that's getting preferential treatment? Are rich and poor being treated alike? What if the poor receive unequal treatment? What happens if the rich receive unequal treatment? There's no good answer to this dilemma. The Supreme Court has allowed its definition of arbitrary to be, well, quite arbitrary. In fact, the court has created 3 levels of judicial analysis for equal protection claims. There are great differences in the legal theories depending on which level is used. These approaches are called strict scrutiny, mid-level scrutiny, and minimal scrutiny. There's nothing in the history or the text of the Equal Protection Clause that justifies creating 3 different sets of legal standards for various kinds of equal protection cases. Now, there is a basis for giving special treatment to racial discrimination, since that was the core purpose of creating the Equal Protection Clause in the first place. But beyond race, it's all made up by the Supreme Court's own personal opinions. And by definition, this is an arbitrary approach to justice. For quite some time, there were only 2 levels of analysis, strict and minimal scrutiny. The Supreme Court said that strict scrutiny was to be applied in cases involving a suspect classification. This is a category that the justices simply invented. Racial discrimination was easily determined to be a suspect classification. And again, there are significant historical reasons for concluding that the elimination of race discrimination was the core objective of the Equal Protection Clause. So let's take an in-depth look at the issue of race discrimination and see where we are on this issue. First, we must deal with the Supreme Court's shameful history on this subject. We start with the decision of Dred Scott versus Sandford in 1856. Dred Scott was a slave owned by a physician in the U.S. Army. Mr. Scott had a wife and 2 daughters who were also slaves to the same master. In 1820, Congress had passed the Missouri Compromise, which banned slavery in the northern parts of the Louisiana Purchase. This 1820 law also prohibited taking a slave from a slave territory into the free territory. Dred Scott had been taken by his owner to Illinois, an act that was prohibited by this law of Congress. Dred Scott argued that as a result of being taken into a free state for an extended period, he became free. The Supreme Court held that in order for him to pursue his claims for freedom, he had to first establish his right to sue in federal court. And the court said that this depended on whether or not Scott could claim the status of a citizen of the United States. Dred Scott was ruled to not be a citizen of the United States despite the fact that he had lived in a free state for a sustained period of time. The court went on to hold that no slave, nor any descendant of any slave, even if he or she was freed by his or her master, could ever become a citizen of the United States. Ever. Listen to the Supreme Court's own tortured reasoning in this case. They had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. In the process of ruling that slaves and descendants of slaves could never become citizens of the United States, the court gratuitously reached out and held that the Missouri Compromise was unconstitutional. States, no matter where they were located, no matter if they were admitted to the Union based on the condition of being slave or free, those states still had the right to determine their own policy on slavery according to this decision. If the Civil War was not inevitable before Dred Scott was decided, it was absolutely going to happen after this decision was rendered. 12 years later, Dred Scott was reversed by the passage of the 14th Amendment, guaranteeing citizenship to every person born in the United States. But the Supreme Court continued to listen favorably to the arguments of racism, even after the language of the Constitution was amended, demanding that the states guarantee equal protection of the law to all persons. In 1896, a challenge was brought to the court against a law from Louisiana that required all railroad companies to provide separate rail cars for white and black passengers. The case was called Plessy versus Ferguson. Plessy was a person of mixed race. He was 7/8 of white descent and 1/8 of black descent. When a rail conductor told him he had to leave the first-class seat that he had bought and paid for in the white section, he refused. He was ejected from the train and arrested. Plessy then challenged the constitutionality of the law that required separate cars for the races. The Supreme Court said the object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law, but in the nature of things, it could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality or a commingling of the two races upon terms unsatisfactory to either. Laws permitting and even requiring their separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either race to the other, and would have been generally, if not universally, recognized as within the competency of the state legislatures in the exercise of their police power. The most common instance of this is connected with the establishment of separate schools for white and colored children. The idea that the decision of Plessy versus Ferguson reflects an equal concern for the citizens of both races is someplace between laughable and outrageous. Nonetheless, the mantra of separate but equal from this case persisted for more than 50 years. Plessy was a shameful decision, but an even more shameful ruling of the Supreme Court was issued in 1944 in the case of Korematsu versus the United States. In response to the war with Japan during World War II, U.S. military commanders ordered all persons of Japanese origin living in certain areas of the West Coast to report to internment centers where they would be held, like prisoners of war. Mr. Korematsu was arrested for remaining in his own home in San Leandro, California. There's no way to describe the order other than being racially motivated. We were at war with Germany, and those of German ancestry were not put into such camps. We were at war with Italy, and Italian Americans were not put into such camps. But it's hard to tell who is German and who is Italian by just looking. The combination of race and national origin were the factors that led to the kind of insidious discrimination that was employed here. Even though the court used the famous strict scrutiny test, which is supposed to be very rigorous, the court upheld the constitutionality of these internment camps. This decision of Korematsu has never officially been reversed, but it is universally viewed as a blot not only on America's reputation, but on the Supreme Court's reputation in particular. It's worth noting that the very liberal Justice William O. Douglas joined the majority opinion in Korematsu, and it was written by the Warren Court's famous liberal Hugo Black. The most famous equal protection case of all time came in 1954 when the Supreme Court decided Brown versus Board of Education. Linda Brown, a third-grade girl, had to walk 6 blocks to a school bus stop and then rode the bus for 1 mile more to attend an all-black elementary school, despite the fact that another elementary school was just 7 blocks from her home. But that closer school in Topeka, Kansas, was limited to white children. This case from Kansas was combined with similar cases from South Carolina, Virginia, Delaware, and Washington, D.C. Each of the cases had been decided in the lower courts on the basis of the separate but equal doctrine from Plessy versus Ferguson. The only school system that was even arguably equal was the one in Topeka, Kansas. All of the other school districts operated patently inferior schools for black children. The Supreme Court finally followed the literal command of the 14th Amendment and ruled that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. This decision was rendered by a unanimous Supreme Court and is without a doubt one of the most courageous and important decisions in the history of the Republic. It took a number of years for this decision to be fully implemented. In the 1960s and 1970s, there were even violent reactions as a number of cases were decided implementing the decision of Brown versus the Board of Education. But there was never any doubt during this period of time as to the correct legal standard. Equal protection of the laws required our society to pursue a colorblind policy in public education. But the area of eliminating race discrimination eventually brought us to a more controversial new idea called affirmative action. Affirmative action is a policy that requires preferential treatment in education and employment for minorities that have been historically the victims of discrimination. However, the counter-argument immediately arose that affirmative action was actually a violation of the 14th Amendment's Equal Protection Clause. It was not a colorblind society. Instead, white students, white employees were receiving unequal and unfavorable treatment. The first major case to challenge affirmative action was Regents of the University of California versus Bakke, decided in 1978. Bakke was a white student who applied to medical school at UC Davis, but was denied admission 2 years in a row, although minority students with far lower credentials were admitted through a quota system that reserved 16 seats for students from disadvantaged groups. In the Bakke case, the parties battled over the correct legal test that should be applied. While both parties agreed that racial discrimination was generally prohibited by the 14th Amendment, there was strong disagreement with the level of judicial scrutiny that should be applied here. Relying on the language from a prior Supreme Court decision, the University of California argued that strict judicial scrutiny should only be applied to persons who were members of a discrete and insular minority. In other words, not only could the laws and policies of the state of California give lower protection to white students, the California government claimed that the Constitution itself had created one standard of equality for minorities and a lower standard of equality for whites. Fortunately, the Supreme Court rejected this argument, holding instead that all racial classifications were subjected to the most strict form of judicial review. In order to justify a racial classification, the interest advanced by the government must be assessed by a two-step test. First, the importance of the government's goal is assessed. It must be shown to be a substantial or compelling governmental interest. In this case, the court held that the university's desire for a diverse student body qualified as such an interest. But all other justifications that were offered by the university fell short. The second step of the test required the court to determine if the government's policy was necessary to achieve this goal. Oftentimes, the way this test is formulated, it asks whether this policy was the least restrictive means of reaching this goal. The Supreme Court ruled that this particular affirmative action program was unconstitutional because of a rigid quota system. It ordered Mr. Bakke admitted to the medical school because he had been the victim of discrimination. However, the court held that if a program of affirmative action used race as a soft factor, that is, one factor among many in an effort to achieve a diverse student body, that was constitutionally appropriate. Those kinds of affirmative action programs have been held to be constitutional in later cases, and programs that have rigid quota systems have been repeatedly held to be unconstitutional. However, in 2007, the Supreme Court turned an important corner. The public schools in Seattle and Louisville, Kentucky, created a rigid system of high school enrollment with quotas for both blacks and whites so that all schools would achieve appropriate racial balance. Neither school system had any recent patterns of racial discrimination which would justify the imposition of quotas as a means of remediating actual practices of past discrimination. The quota system was defended solely on the basis that there was a compelling governmental interest in having racially balanced schools. By a 5-4 vote, the Supreme Court ruled that such affirmative action programs were unconstitutional. The court's language is worth reading closely. Accepting racial balancing as a compelling state interest would justify the imposition of racial proportionality throughout American society, contrary to our repeated recognition that at the heart of the Constitution's guarantee of equal protection lies the simple command that the government must treat citizens as individuals, not as simply components of a racial, religious, sexual, or national class. Allowing racial balancing as a compelling end in and of itself would effectively assure that race will always be relevant in American life, and that the ultimate goal of eliminating entirely from governmental decision-making such irrelevant factors as a human being's race will never be achieved. The policy of affirmative action has not been totally eliminated by this 2007 decision, but its growth and expansion has certainly been curtailed by this decision that's very unpopular with the political left in America. Now, while we're here, it's worthy of note that virtually every UN human rights treaty requires the nations that are parties to the various treaties to pursue policies of affirmative action, both in the areas of race and gender. So if we become parties to all these treaties, we will no longer be able to pursue a colorblind society, but will instead be permanently bound to a system of enforcing a rule requiring certain kinds of discrimination. The history of strict judicial scrutiny for racial classification shows that the Supreme Court has failed to consistently grasp the meaning of a colorblind society and has erratically permitted some kinds of discrimination on the basis of race, depending on the societal attitudes of the day. Sometimes they pursue a colorblind rule, and other times they get around it, depending on shifting attitudes and personal opinions of Supreme Court justices. As we noted earlier, strict scrutiny is one of the two original standards for equal protection challenges. The other standard is called minimal scrutiny. And as usual, the Supreme Court just made these standards and all the rules that go with them completely out of thin air. But let's look at a case using the minimal scrutiny test so you can see how it works in actual application. In the 1979 case of Vance versus Bradley, federal foreign service officers sued the federal government for age discrimination in violation of the principle of equal protection. It's worth noting that even though the Equal Protection Clause is written in the 14th Amendment to apply only to the states, the Supreme Court has interpreted the Fifth Amendment's Due Process Clause, which literally applies to the federal government, to include the ideal of equal protection. While the result is a just one, the logic of using the Due Process Clause, written in 1791, to include a concept from the 14th Amendment, written in 1868, defies some basic principles of time and space. If I were on the Supreme Court, I would have held that the Ninth Amendment, which reserves rights that are historically grounded but not specifically enumerated, protected the rights of all Americans to be treated with the principle of equal protection by the federal government. In Vance versus Bradley, a Foreign Service officer challenged the law of Congress, which required all Foreign Service officers to retire at age 60, whereas all other federal employees were not required to retire at that age. Ironically, 7 members of the Supreme Court were over the age of 60 at the time of the hearing of this case of age discrimination. Here's the legal standard used by the court to decide this case. We will not overturn such a statute unless the varying treatment of different groups or persons is so unrelated to the achievement of any combination of legitimate purposes that we can only conclude that the legislature's actions were irrational. This test can be summarized by saying that a law will be held constitutional despite treating groups differently if it is rationally related to furthering a legitimate state interest. The government argued that because they were living overseas, sometimes in very difficult locations, they needed young, vigorous officers serving in the Foreign Service. And the Supreme Court said, basically, that's close enough. Because whenever the court uses the minimal scrutiny test, almost always the government wins. It's not a rigorous test at all. It is truly minimal scrutiny. But the Supreme Court is not content to just make up these tests, invent them out of thin air. They like to remodel their own test, adding a front porch or a back patio later. And that's what they've done by adding a third test to the equal protection area of law. They've done this in recent years as we've seen the Supreme Court add a new third test called intermediate scrutiny. As the name suggests, it's not quite as strict as strict scrutiny, but it is more vigorous than minimal scrutiny. Intermediate scrutiny is applied to cases involving gender discrimination. Two cases concerning college admissions are among the leading gender discrimination cases in the Supreme Court. The first was Mississippi University for Women versus Hogan. Joe Hogan, a male, wanted to go to the university to get an advanced nursing degree. He was already a nurse. He was refused admission solely on the grounds that he was a male. The legal standard employed in this and other cases using intermediate scrutiny is that there must be an exceedingly persuasive justification for the different classifications. 4 justices on the Supreme Court found that the university's rules were exceedingly persuasive. 5 justices were perhaps swayed, moved, perhaps even leaning in their university's direction, but they were not exceedingly persuaded. Actually, the majority didn't appear to be persuaded at all by the university's arguments. Mississippi argued that it needed to exclude men because women had often been victims of discrimination. The court rejected this theory of reverse discrimination. In 1996, the Supreme Court turned the tables and ruled that the Virginia Military Institute's policy of not allowing women to become cadets was unconstitutional, despite the fact that the VMI program has a famously excruciating physical standard for their freshman class. Nonetheless, the court said that the reasons for discriminating against women were not exceedingly persuasive. The outcome of equal protection cases depends entirely upon which test is used, and the choice of test is simply arbitrary. That's not a way for the Supreme Court itself to guarantee equal protection of the laws to all citizens of the United States.